So thank you for being here. Also for this last speech, and then we have the debate between the panelists, among the panelists and delegates who would like to intervene. We have a portable microphone. As usual, we are a little bit late on the schedule. But we will try to take it up, and in any event the bus is leaving from the Hotel Excelsior, which is 5 minutes walk, at 8 o'clock. So I think we may want to end at let's say not later than around 7:15, 7:20, so we have a comfortable time to go to the hotel and perhaps have a little, the people who are staying in the hotel to refresh. So I've invited some, we are going to this speakers party, which is extended to all the not residing delegates, and also to those of you who would like to join us. They are very welcome. It will be a very happy party at Villa Doria d'Angri, overwhelming the Bay of Naples. My last paper should be in principle a legal paper, but there are two objection to this. The first one that I have been writing after I finished organizing the conference last night very quickly, and the graphic people, they have made a very beautiful work, but perhaps some of the English spelling, I think they are the artists don't always perhaps in the rush. There might be some clerical mistakes. At the same time, I'll a bit play by the ear, because this doesn't want to be a full legal paper or speech, but it wants to be a speech or talk about negotiating contract for vessel, sector I have a certain experience, and in particular with for high-performance vessels. With Mr. Bocchetti, who just spoke, we did recently, not so recently, but the contract for the 5 largest row-con vessels of the world that have a very high performance. I mean, this is a problem that also in the existing contract we always had. What happens if the builder or the makers, they cannot perform according to the vessel specification? And I will not propose solutions of perhaps loopholes or legal subtleties. Okay, you can try to bypass or to get into the legal limitations that often this contract have in favor of the builder of the vessel. But I'll speak a little bit about the way we should address the negotiation like this, which is for a vessel that is generally built on the basis of a better performance than the old-fashioned vessels. So what is the main question for a contract? How can we provide a remedy if the contract is not fulfilled? So if this specification are binding the international rules on emissions and making the vessel to perform in a better way than the existing vessel are not fulfilled, this could depend on a series of causes. What is going to happen, and what are the remedy that the innocent party, in this case the ship owner or the contractor, could have at this disposal? And this leads to answer the next question, the following question. So how big is the damage that not breach in the shipbuilding process in building or assuring that the ship is compliant with the specification is. Obviously, there are cases in which the defect could be eliminated and perhaps just the delivery delayed. All the forms general contract provide for a long period, sometime up to 6 months, 180 days, and perhaps during this period the defect could be eliminated. It's very seldom that the vessel could be eliminated under the guarantee. First of all, because there will be no compensation. First of all, because today the majority of the commercial vessels are built in the Far East. And so, eliminating a vessel which was not possible to avoid in the shipbuilding contract would be very difficult to be done in totally different sceneries, particularly if it's a design problem. It's not a material or problem that perhaps could be put right. The second problem is that under the, and perhaps you should open a discussion, but it would be too long for today, under the existing customary guarantee clause, nobody pays for the time of the refitting repair works, and nobody pays if after this the vessel is still partly not fulfilling the contract. Because this is the guarantees are limited to the cost of the repair. So the vessel should be detected at the time of delivery, if not before, and the problem should be addressed. A good contract for a vessel should allow the performing party to get this from the non-performing party. In this case, we are speaking about the builders. How much is the damage? Well, I think the very artistic graphics, this slide was organized a bit different, so I will have to explain it. I think when the first vessel were, as we discussed yesterday also with Umberto, were first built, the extra cost amounted to about 20-30% more than the old-fashioned vessels. So 20-30% of the price could be perhaps a sort of quantification of the prejudice sustained. Yes, it could be. Today all vessels are, almost all of them, are eco-vessels, okay? We can, high-performance vessel, abiding the regulation, also the prospective future regulation. But I think in some cases, in many cases, and it's a pity that Emmanuel had this very frightening problem that went well with his plane, are based on a narrative which is not a pure narrative, is a feasibility and business project and business plan. The purpose is how, even though we have a situation of excess of tonnage today, the owners or the other investors who are building new generation vessels, they say, okay, there is an excess of tonnage, but we will build a new vessel which will outperform the existing vessel, and if like Mr. Bocchetti, Grimaldi, if they, I mean, for Grimaldi, I think over 2 billion, 800 million of sales, of revenues. The cost of bunker is over 800 million. So represent almost within 30%. So it's very, for an owner like Grimaldi, like MSC, like Maersk, who has line, is immediate competitive advantage. I mean, For an owner who is chartering, and we have many of them, time chartering the vessel, is obviously a preference to get a better hire and first employment, especially in a difficult market situation. Because it's clear that the charter, tomorrow we will have also at the conference some charters, is for obvious reason, is fixing first the better performing vessels and the higher rate. So sometime if a project is based on the fact that there is theoretically no room for old-fashioned vessel, but there is room on the market for a better performing vessel, theoretically the full value of the investment of the vessel is at stake. Let's say less the scrap value, or perhaps we can be a little bit more generous. I've got Jeff here. Yeah. I mean, these are a little bit theoretical things because generally breaches are not so big. We are dealing with points. But if we want to make to bring the reasoning to its consequence, we have to have very clear these two factors. This is from Umberto D'Amato. He already showed it to you. It's my main source of technical and ship-owning force. We are dealing with a price of IFO of about 550. This is, if we take the performance of a Panamax vessel, eco type, we can find a saving. Generally, Umberto's figures are quite cautious of 5 tons a day. So we want to quantify the prejudice because we want to speak during the negotiations on certain terms with the builders, and there are also many equipments and makers. The prejudice because we want to speak during the negotiations on certain terms with the builders, and there are also many equipments and makers, makers of engine and equipments, and obviously this conversation, this interest also them as well, because they are at the final end. So I made some sort of calculation. I'm one of the very few lawyers who know arithmetic, so perhaps this is all wrong. It's just a joke. And I calculated for a Panamax, 1 point percentage is during the 20 years, and I know some owners in the Far East who can make the vessel live much longer. For 20 years of life of a bulk carrier, Panamax is about 1 million. Obviously, we offset the fact that this money is saved during a period. Obviously, we have to assume that the price of the oil will stay the same, will increase just slightly. But it's a pure guesstimate, but it's not far from, with an increasing oil market, this would be much more. Obviously, liquidated damage. Among Italian and Greek owners, they very often speak about, some of them, penalties. And penalty in Italian law could work sometime. In Greek law too. Unfortunately, I'm becoming quite familiar a little bit also with Greek law. In English law, as many of us know, penalty is legally unenforceable. So we should have liquidated damages. And but the other remedy when the breach is very big is the contract rescission. But what is liquidated damages? According to the main case law statements, is a genuine pre-estimate of the losses arising from the breach, and the compensation for the breach should not be extravagant or unconscionable. Otherwise, we are in front of a penalty, even though we call them liquidated damages, which is null and void or legally unenforceable. All these judgments, this case law, refer to or unconscious compensation. Unfortunately, I don't think that as far as the law, the status of the law is now, there is not the opposite way of exit, that if the liquidated damage is too low, it becomes legally unenforceable, and so the owner would have the right to be compensated in a more reasonable way for the loss he sustained. So liquidated damages is in fact a way to limit the liability. As the owners have in their favor the international conventions, the maritime codes, the common law, and they limit liability as carriers, for instance, or in other ways, ship owners' liability convention. These shipbuilders, they don't have all this. They are engaged in a very risky business themselves, or no ship is similar to the other. And they have historically achieved, unless they don't negotiate with some of these very clever owners I can see in the room, and some of their lawyers, they've always been able to keep the almost the liability very low with not reasonable liquidated damages. In fact, for a vessel which has an underperformance of 6.5%, if we have a rate of US dollars 200,000, which is not bad, I mean, you don't have, you in front of, towards, you know, a damage of about 6.5 million would be compensated with 300,000. I like, you know, to speak about numbers, because numbers tell us a lot of things. It's not only the principle of the law. In the end, is the number that matter. And I think this should be, when we sit at the table, we should tell the people, okay, I'm sure you'll make a beautiful vessel, but you should guarantee in legally binding terms and a contract if you want to have liquidated damage, which is understandable, is reasonable, because okay, unlimited liability from a shipyard is not, you have to be realistic. But we will have to discuss and fight and confront a lot in the two industries too. I'm sorry that we don't have the chairman of, is one of the other missing, not showing, the main two not showing up person of this, Vincenzo Petroni, who was fixed a launch, he had to attend. But certainly we will have to speak again about this, and perhaps also the classification society could be part of the discussion as well as the owners. Yes, sorry, Mr. Builder, liquidated damage should be increased. Well, I already said what is written here, so I will not entertain much longer. Perhaps this is a bit more articulated, even though it was late in the evening last night, and I had John Liras and Yanis waiting to have dinner with me, and they didn't want to be late. But I think we exactly understand what we mean. The problem of the franchises, when you have up to 5% franchise tolerance, this is even 3%. So if you want to have an eco vessel, you cannot have a tolerance of 5%, 4%, 3%. I think if there should be a tolerance, should be minimal, should be something that even the testing may be not. Should be just a tolerance for some little, because you pay 1 million for each point. This is one of. So also the problem of the test is a bit wide. Workshop test. We have again the classification society. I think we should even perhaps arrive to a system in which we have a very thin tolerance for workshop test, a little bit wider tolerance for the laden vessel. Because let's not forget, I think everything is a little bit joined. Let's not forget that these savings are sometimes the result of the design of the hull, of the propellers, of the rudders, of the materials of the coatings. We spoke about silicon, but what happens if the design of the hull is not working? It's working well in the on the model test and then on the actual vessel. I don't think that just one of the parties can bear the risk and the cost of this. Obviously, what is another thing that has to be changed, we cannot have so much, we should not favor litigation. I probably will not, I don't know if all my colleagues would agree, but I'm sure that many in the end will, because they are very conscientious lawyers. So we should avoid litigations, but we cannot have this type of situation that you could be delivered a substantially not performing vessel and you have to accept it with just liquidated damage that, as we saw, will never be able to raise them in order to compensate. And even if they will compensate us, they will be bad vessels, and this will be bad for the industry, will be bad for the charters, will be bad for the international trade and traffic. So, with eco ships, a new era has started. Perhaps we cannot speak, as has been already said, about eco vessels, but this is the aim, to increase the level of the industry in order to make keep also in life at least the best shipyards, which are able to make high performance vessels, but they should be also able to guarantee, because everybody can say, okay, I'll make a beautiful vessel, but then if it's not performing, it's just creating a very bad problem to the owners who invested heavily in the existing fleet, and is not producing anything good for them, for the new investment, if possible, for the world, for the benefit of the economy. So yes, I conclude this little talk saying, dear negotiator, good luck, because it's very important that you succeed. Thank you very much.